Yes, welcome everyone to the Bariar's IS PYQ Mela. Today we are going to discuss the polity mains questions of year 2025, and also we are going to discuss how should you write the polity answers. So before I start, please confirm whether audio video slide is all clear to all of you. Yes, students, please confirm whether audio video slide is all clear. Yes, it's clear. Thank you, Anhita. So let's start the discussion. So first you need to understand what's the element of good answer for polity. I think you all are aware that GS that polity questions are asked in GS paper 2, and you get around 8 to 10 questions of polity in GS paper 2. And the kind of questions you got of polity is conceptual, like you could be asked about judicial activism or separation of power, constitutional morality, etc. Then certainly analytical, because it's a descriptive paper. Mains is a descriptive paper, so you will be asked analytical questions, right? So you will be asked what are the pros and cons of tribunals, or how the state reorganization affect federalism, or how the recent changes in financial relation impact the state autonomy, and so on. Then there will be certain questions of dynamic nature. It means linked with current affairs. For example, the recent Jammu and Kashmir Reorganization Act could be asked. For example, in 2025 itself, it has been asked, right? So these three kinds of questions are going to be asked in UPSC mains. As we discuss 2025 mains questions, you will get further clarity of it, right? So now, what you need to remember to write a good answer in polity. First, there should be a clear structure of your answer. What do you mean by structure? It means putting right things at right place. Right things at right place. It means you know that every answer has three parts. One is introduction, second is body, and third is conclusion. So structure of your answer shall ensure that whatever things should be there in introduction part or in the beginning of the answer should be written in introduction. Whatever information which should be written in your main part of your answer, that's where you are going to do the analysis, or there you are going to do right the there you are going to address the demand of the question in body part, right? And things which should be written at the end of the answer should be written in concluding part of your answer. You get the point? So the essential crux of writing a right structure is things which are meant for introduction, things which are meant for body, and things which are meant for conclusion should be there only. You should not jumble up the things of body in introduction, or thing of body in conclusion, or things of conclusion in body, or so on. So that's the first part. Then second thing you need to remember for writing a good answer is logical flow. It's logical flow complement, or you can say a natural corollary of structure. What does it mean? Things you are writing in introduction, body and conclusion should be interlinked, interrelated with each other. The examiner, while reading your answer, should have smooth experience of what you want to convey, right? Or he should have a smooth experience of addressal of the question in your answer. That's basically the logical flow, right? So whatever being asked in the question, you are going to write in body. So introduction and conclusion should be related with body, right? So for that, you need to little bit apply your mind before answering the question. What do I mean by it? Before answering the question, just think for 30 seconds to 1 minute of what you are going to write in introduction or in body or in conclusion. Then start writing your answer. Do not jump hurriedly to write the answer just by reading the question. You get the point? You need to read the question twice and thrice, then think for 30 seconds to 1 minute, then start writing the introduction, body and conclusion of your answer, right? So if you just give a little bit time before writing the answer, your introduction or conclusion will be so apt that examiner will enjoy while writing your answers. And how you will make sure such logical flow in your answer, you will get idea when we will discuss the previous year question of 2025, right? So now, what is the third aspect that you need to make sure for writing a good answer of polity? You should write as many as constitutional articles as possible, right? You should write Supreme Court verdicts, important Supreme Court verdicts in your answer, right? Then you should write examples or current affairs, anecdotes in your answer, right? And also you can add any committee or commission's recommendations. For example, Sarkaria Punchi Commission or Administrative Reform Commission recommendations or Dinesh Goswami committee recommendations, etc. That will make your answer enriched, and that will help you to get as many marks or as highest marks as possible. But you need to remember, do not overdo it. Do not overdo it. Do not put these things in excessive amount, right? It should be related with addressal of the need, or you can say demand or requirement of the question. How? Again, I will let you know while we start discussing the answers of the 2025 mains questions, right? So these things you need to remember for writing a good answer of polity. Now coming to the types of conclusion. In previous session, Indrajit sir has listed out certain types of conclusion you can write in your answer, like the summary conclusion, where the whole discussion is basically summarized or written in brief at the end of the answer, or suggestive, where you are writing certain suggestions. These suggestions could be your own or could be of any committee or commissions, right? Or the balanced conclusion, where you are just providing a balanced opinion at the end of the answer. Or visionary, where you are giving a futuristic outlook to the question, right? Then there could be value-based conclusion also. It means you can write a quotation to write a conclusion for your answer. How these things could be put, again, I am going to discuss with you while we are going to discuss the 2025 questions of mains, right? So a brief actually you got how your answer should be, right? Now we are going to discuss how could you write the mains answers. The first question that we are going to discuss is comment on the need of administrative tribunals compared to the court system, right? Second part of the question is assess the impact of the recent tribunal reforms through rationalization of tribunals made in 2021, right? And you have to answer it in 150 words. So it was a 10 marks question. So for 10 marks question, UPSC will give you 2 pages, right? But UPSC has asked you the need of administrative tribunals, then it has asked you the tribunal reforms undertaken of rationalization of tribunals, then it has asked you the impact of such reforms, right? So it means it's a lengthy question. But the space and the word limit and the time limit provided to you is limited. So for these kind of questions, you need to remember that you need to write in concise manner only. Do not explain any point. Otherwise, you will not able to address various subparts of the question. You will miss 1 or 2 subparts of the question, thereby losing the marks, right? So your points, your example should be ultra concise and precise, right? In these kinds of lengthy question, never ever try to explain anything. You get the point? First thing. Second, the body part. First we are coming to the is need of administrative tribunals, right? Then the impact of recent reforms, right? Then now the question arises, what should be your introduction and what should be your conclusion? And I've told you that you should maintain a logical flow in your answer, right? Body is clear for you that you need to write need and also the impact of recent reforms. So introduction should be a brief about tribunals. Let the examiner know about what do you understand by the term tribunals. So tribunals are quasi-judicial bodies which have executive members to adjudicate the disputes, right? To settle the disputes, to adjudicate the law, right? So that definition of tribunals you can write in introduction. So here definition based introduction you can give, or the second introduction you can give of constitutional article. So constitutional article named 323A and B deals with tribunal under part 14A of the constitution. You get the point? Just write that. Or you can write both also, tribunals definition and constitutional articles, but it's a lengthy question. So I will suggest you either write definition or constitutional article, or write it both in ultra brief manner, like tribunals are the quasi-judicial bodies to settle the disputes having executive members, and they are established as per article 323A and B of the constitution of, right, and of part 14A, right? So that should be your introduction. Clear? Because here in introduction you are giving examiner an idea about what do you understand by tribunals and what's its constitutional basis, right? Then you are coming to the need of the tribunals. You get the point? So that will ensure your logical flow. If you suppose write limitations of tribunal in the introduction, so it is going to break your logical flow. Every story has an introduction, has a body and has a conclusion, right? You start your story with the statement like, once there was a king, right? You never start a body introduction by saying that the king was killed in a battle. You get the point? So this line, the king was killed in a battle, could not be written in introduction. You get the point? So for introduction, just introduce the concept of tribunals to the examiner, right? An introduction should not be more than 2 lines, right? It's a lengthy question, but that is a 10 marks question. Already you have limited space, right? So you can't waste your time or word limit or space for introduction. You get the point? Yes, just 2 lines, right? In 2 lines you can give a definition or constitutional basis to tribunals. You get the point? Then straightforwardly come to the main body part, that's need of administrative tribunals. You get the point? But read the statement completely. Comment on the need of administrative tribunal as compared to court system. Right? So UPSC is asking you, you need to compare the need of tribunals vis-a-vis court system. So little bit comparison should be there. Right? Why we need tribunals in place of court system. See, the points which you write of, see in this section, you are going to write the points of significance of tribunals. But the wording should be such that it is expressing the comparison with court systems. You get the point? For example, obviously you will write about tribunals, that tribunals ensure the speedy justice, timely justice. Tribunals ensure cost-effective justice. Right? But in your wording, comparison with court system should also be included. Right? The courts, the regular courts which take years to decide upon the case, tribunals resolve it quickly, timely, and in cost-effective. That could be done, but if you draw a table, right, of tribunals and courts, right? So here you are basically addressing the question of difference between tribunal and courts, right? But the question is not about difference between tribunal and courts. It's basically saying need of tribunals as compared to courts, right? So that's why little bit elaborative method you should follow, right? Then you can talk about tribunals offer specialization in handling or resolving the disputes, right, as compared to courts, which are manned by judges who have knowledge, experience in law but not in technical matters, right? And you can give examples of NGT or income tax tribunal and so on, right? Then it also ensure accessibility, because tribunals are cost effective. Then tribunals branches are established throughout the country. For example, of Central Administrative Tribunal has 17 branches, right? So thereby ensuring access to justice to people, right? And also it reduces burden on judiciary and so on. So these points of need of tribunals you can write in courts, and you can add more points like tribunals offer you flexible procedure to get justice, because tribunals are not bound by Evidence Act. Tribunals are not bound by Code of Civil Procedure, right? Even in tribunals you can fight your own case. You do not need lawyer's service, right? So these points are a little bit comparative with regular courts. So you are addressing the first subpart of the question effectively. That will be reflective of, again, tabular system provided in vertical format. Yes, you need to write in first one paragraph only. You need to write about this. You do not need to refer courts in every point. If I say tribunals offer flexibility in its procedure, as it is not bound by Code of Civil Procedure and Evidence Act, unlike regular courts. You get the point? Even if I do not write unlike regular courts, then also the point itself is signifying that we are establishing tribunals over courts because it provides us flexible justice. You get the point? So it means wording should be such which give a clue over of comparison with courts, right? Then there is a tail word, comment, right? That also you need to address. Comment means you have to give your opinion also. Here UPSC is asking your opinion, right? So after writing need for tribunals, just write a single line that tribunals has helped to resolve the pending cases of regular courts, right? For faster just that point is already written in need, right? You just write about it, helps to reduce the pending cases of regular courts, right? But tribunals has been over proliferated in recent years, right? So this opinion will subject or will set the premise for addressing the next subpart of your question. That's basically the impact of tribunals reforms of rationalization of 2021, right? So here the UPSC has asked you impact and that to its assessment, right? Whether they have proven beneficial or not is being asked by UPSC. So it means this subpart has three components. One is what were those reforms of rationalization? Second, impact. Third, its benefits and criticism. You get the point? So that's why here again you need to be cautious that you are ultra concise and ultra precise in your expression, right? So in 1 or 2 lines, just write that through Tribunal Reforms Act 2021, certain tribunals has been merged and certain tribunals has been abolished, right? And the regular courts jurisdictions has been restored over those matters. For example, the Film Appellate Tribunal or Airport Appellate Tribunal, or you can talk about Intellectual Property Appellate Board, right? And so on. So if you write just 2-3 tribunals which has been abolished or which has been merged, etc., that's more than enough. You get the point? Clear? Then it says rationalization of tribunals. We have write the point. We also use the word reforms, right? So there were other reforms also undertaken by the government through this act. For that also you will give just a brief line that the government has tried to streamline the appointment procedure, the tenure, the pay, the service conditions, etc. of tribunals members. You get the point? Do not elaborate it. Just write this, that government has standardized or streamlined tenure, appointment, service conditions, etc. of tribunal members, right? Then you need to write about the impact. For that you need to write about positive and the criticism. Again, that should be in ultra brief manner. For example, streamline the structure, right? And improve the consistency, because these disputes now will be handled by regular courts whose appeal shall lie in high courts, right? High court jurisdictions get restored because sometimes tribunals were encroaching upon the jurisdiction of high court, because tribunals verdicts sometimes are directly challengeable were in Supreme Court, right? Then you can talk about other points also, like it reduced the expenses on the public exchequer, right? Or it provides clarity to the litigant where to file the case, because earlier he was confused whether to file in regular court or in tribunal. You get the point? Then you need to write concerns that more lakhs of cases are pending in high courts, crores are pending in subordinate courts, and regular court lack expertise, right? And the existing tribunals are lacking independence as observed by Supreme Court in Madras Bar Association. So see, here Supreme Court verdict we are mentioning, but we are not making it a separate subsection in our answer. We are just associating it with the point. The point is tribunals are lacking independence as observed by Supreme Court in Madras Bar Association case. Even if you do not remember this Madras Bar Association case, just write it as Supreme Court observed in one of its verdict, or just simply write as Supreme Court observed. You get the point? So that's how you are going to add Supreme Court verdicts in your answer, right? Then in conclusion, you can talk about a balanced conclusion, like neither um, yeah. So balanced opinion will be, we need right sizing of tribunals, right? Neither we require excessive tribunals nor we require lesser tribunals. We need right number of tribunals, right? For that, empirical studies should be undertaken. Or you can write about a suggestive conclusion, giving few suggestions. For example, right sizing, that's the first suggestion, or empirical studies, right? Or third could be ensuring the independence of tribunals as suggested by Supreme Court, providing them necessary infrastructure, staff, then creation of national tribunal service, right? And so on. So these kind of suggestions also you can write in your conclusion. Clear? But this is 10 marks question, again 2 pages are being given, so you may not have the space for suggestions. For that purpose you could go for balanced conclusion, right? Because space is very limited in this answer. For that, try to see if the conclusion is of nature of balanced one, or visionary one, or summarizing one. That should be of 2-3 lines. But the solution or the conclusion is of suggestive one, then conclusion will be elaborative, because at least 5-6 solutions you need to write for 10 marks question, and 8 to 10 suggestions you need to give for 15 marks question. You get the point? So suggestive conclusion will be lengthier one, but the balanced or summary or value based or futuristic conclusions will be shorter ones. You get the point? So now coming to the second question. Again, it was asked in 10 marks. Let's basically discuss the nature of Jammu Kashmir Legislative Assembly after the Jammu and Kashmir Reorganization Act 2019. Right? Then briefly describe, again UPSC have specifically write briefly, so do not elaborate it. Right? Describe the powers and functions of Assembly of Union Territory of Jammu Kashmir. Right? Again, 2-part question. Right? First we will discuss body part. The word is nature of Jammu Kashmir Legislative Assembly after Jammu Kashmir Reorganization Act 2019. It means some comparison you need to make of Jammu Kashmir Assembly before reorganization and after reorganization. Right? Then the tail word is discuss. Tail word is discuss. It's not explain, not describe, it's discuss. Right? So here you could add certain points of significance or concerns of such change of nature of Jammu Kashmir Assembly. You get the point? So the first subpart will include what is the changes, what are the changes in nature, then briefly, only briefly, the importance and concerns of such changes in nature. Impacts also you can add, but very briefly, right? These all things should be there in 3 lines, like in 1 line importance, in 1 line concerns, 1 line impact, right? Then here the tail word is describe, right? Here never do the analysis, right? Never do the analysis, because the tail word is describe. Just simply explain the power and functions of Jammu Kashmir Legislative Assembly, right? If you here provide the importance or the challenges and so on, marks will be deducted, because you are overwriting here, right? Here if you do not provide importance, concerns, impact, etc., that too briefly, because the tail word was discuss, right, then marks will be deducted. You get the point? So now coming to the question, right? So that's body part, I think is clear to you. So what should be the introduction? Introduction should set the premise for body part, right? Conclusion should end put an full stop to your body part. Should put a cover on your body part. Get the point? So how introduction will set premise for this body part? Just talk about that Article 370 used to provide special powers to Jammu Kashmir, but such special powers were withdrawn by Article 370 abrogation and Jammu and State Reorganization Act. Right? So it sets a premise for your first body part. Very good. Right? So Jammu Kashmir Reorganization Act you can talk about. Right? Bifurcate the state into two UTs, one with legislature and one without legislature. Right? Then coming to the nature of Jammu Kashmir Legislative Assembly, earlier and now. Earlier, bicameral, you can write like from bicameral legislature to unicameral legislature, right? From 107 seats to 111, sorry, from 111 seats to 107 seats. You get the point? 24 reserved for POK, 83 for Jammu and Kashmir, right? From 6 years to 5 years. So here you can follow the format of from to now. You get the point? Then earlier there was separate constitution for Jammu Kashmir. So Jammu Kashmir Assembly was operating under separate constitution, now under Indian constitution. Right? Jurisdiction earlier has greater over state and concurrent list, now over state and concurrent list, but except land, police, public order, etc. Right? Residual power earlier with Jammu Kashmir Legislative Assembly, now with Parliament. Right? See, here you have been asked nature of Jammu Kashmir Legislative Assembly, not the Lieutenant Governor powers. You get the point? You need to focus upon Jammu Kashmir Legislative Assembly. Do not give elaboration of Lieutenant Governor power. Right? But we know that President or Governor are also part of legislature. Right? That's why a brief you could give of Lieutenant Governor power. For example, Lieutenant Governor can reserve certain matters for President consideration. Example of affecting center-state relation or peace or interests of minority, SC, ST, etc. in the state. You get the point? So that should be written in last, that too in brief. This point should not be your first point, because the question is asking you nature of Jammu Kashmir Legislative Assembly. No, that details you please don't write. No, you are, if you are saying that you will write Lieutenant Governor as agent of President. So basically you are explaining the administrative system of the UT with legislature. Here you have been asked nature of Jammu Kashmir Legislative Assembly after 2019, right? So after 2019, LG role get enhanced as compared to the governor of the earlier Jammu Kashmir as state, right? Because it can reserve certain bills or certain matters for President consideration. For example, affecting center-state relations or peace, tranquility, or affecting minority interest, etc. That one line you should write in the last, not in first. You get the point? That too just in single line. You get the point? You should know which point you will emphasize and which point you will write, you will undermine. You get the point? Then coming to the powers and functions of assembly. Here you may get worried that you have not read the power and functions of assembly. Then what should you write? See, you know about the power and functions of legislature. Just make those power and functions of legislature as power and functions of assembly. So what are the power and functions of a legislature? First is lawmaking, that's legislative function, right? And we know that Jammu Kashmir Legislative Assembly does not have a legislative power over police, public order and land. Then second function is government formation, right? That also you can write that Jammu Kashmir Legislative Assembly will elect its leader as CM, and such CM will appoint its team, that's Council of Ministers, amongst the member of Legislative Assembly. Third is providing finances to the Council of Ministers, to the government, right? So you will talk about Jammu Kashmir Legislative Assembly will certainly pass the budget or money bills, etc., to authorizing money to government. Then fourth function is holding such government accountable by questions, by judgment motions, by no confidence motion, etc. Right? And fifth is representative function. It will represent the people of Jammu and Kashmir. Right? For that you can talk about that 47 seats are given to Kashmir, 43 to Jammu. Right? And in which 2 seats will be filled through nomination for Kashmiri Pandits. Right? And 9 seats are reserved for ST, 7 for SCs. Right? That you can write in representative function of Jammu Kashmir Legislative Assembly. If you do not remember these facts, just talk about that certain seats are reserved for Kashmiri Pandits, SC, STs, etc. That also enough for your answer. Right? If you write specific, well and good. Even if you give the idea that you know that certain seats are reserved, right, for SC, STs, and also by nomination for Kashmiri Pandits, right? Then examiner will give you the marks. You get the point? Then how will you conclude? How will you now end up the things? You can give a futuristic outlook. Here, a visionary conclusion you can give, right? So you can talk about that statehood of Jammu Kashmir should be restored, right? It should be converted from UT with legislature to full-fledged state, right? And state government should function in coordination with central government to end insurgency or separatism sector in the state, right? That's a futuristic outlook you are giving to your answer. You can talk, you are talking about to continue Jammu Kashmir as UT with legislature. So then you can talk, you can frame your conclusion in this manner. For short period of time, Jammu Kashmir as UT with legislature should continue till we end the terrorism or cross-border terrorism or separatism insurgency in the state, right? Moment the security situation get improved, we should restore its statehood in long term, right? Because here limitations or criticism etc. is not asked. So that's why suggestive solution will not work, right? Here there is no such pros and cons. There you need to give a balanced opinion, right? So that's why here a futuristic outlook will be better for concluding your answer, because you have start with a change, you have prescribed the change, right? Then you are letting the examiner know that where this change should go. You getting the point? So you are able to understand how the logical flow in the answer is maintained, right? So examiner will enjoy while reading your answer and will give you highest marks. You get the point? So structure, the logical flow, idea you are getting, right? And how to address the tail words like discuss, describe, examine, right, comment, etc. You're getting the point, right? And how you will express your ideas in concise manner. How will you associate Supreme Court verdicts or constitutional articles, right? Or the case studies or the current affair anecdotes or examples or committee commissions recommendations in your answer. You get the point? So these things you need to be careful about while writing the answers, right? Clear? So I have given you a broader, a model answer, right, of every PYQ. So do you remember, it's a model answer, not a best answer. Model answer means a reference answer. Yes, just to get an idea, like what could be the possible answer of it. But it's not a best answer. So you must have observed that we have deviating from what is being written in model answer. Our introduction is different. Our body points are different. Our conclusion is different from what is being written in model answer. You get the point? So do remember, model answer is not a best answer to imbibe by or to inspire from. It's just a reference answer. Just to get an idea of what could be the basic answer to this question. You get the point? Because such answer could further be increased. For example, you can add some examples in power and functions of Jammu Kashmir Legislative Assembly. Right? For example, in government formation point, you can add recently elections held and Jammu Kashmir Legislative Assembly has elected its CM, right? And Council of Ministers headed by Umar Abdullah. That example you can add. Or any law you remember of Jammu Kashmir recently passing, you can add. You get the point? So more the examples you add, more the marks you will get. So the point is, this model answer is not the best answer. Best answer will be of yours, right? So these things could be further better presented through flowchart also, isn't it? I've just written a point format. You can make a flowchart, like how you can make flowchart. For example, this is your sheet of paper. Just you can make this kind of table. Here you will write about legislative function, right? Here you will write government formation function, right? Here you will write financial function, and the explanation of this function will be here. You get the point? Kind of a tabular format you can follow, right? Or you can make a flowchart in this manner also, like power and functions of legislature. Make 4 subheadings here: lawmaking, government function, government formation, financial function, representative function. Then explain it, right? Explain it. Then here write example. You get the point? Here explanation, example, if any, right? So answer could be taken to, right, any level. That depends on you, right? That's why your answer will be best one, not the model answer. Clear? So sky is the limit for doing improvements in the answer, right? Now coming to the third question. Attorney General of India plays a crucial role in guiding the legal framework of union government and ensuring sound governance through legal counsel. Discuss his responsibilities, rights and limitation in this regard. Right? So here again a 10 marks question, 150 words. Again a lengthy question in 10 marks. Again you need to be cautious that you write in concise and precise manner. Right? So what are the body parts of the question? One is directly mentioned responsibilities, rights and limitations. Right? Again you need to prescribe. Right? Then the tail word is discuss. Right? If the word is discuss, then something greater than explanation you need to go in the answer. Right? So responsibilities, rights, limitations you know about. Right? You read in your static portion, in your classes, in your textbooks. You will surely write it. Right? But something extra you need to add. For example, are these responsibilities enough or some new responsibility should be added? That you can write in conclusion. Right? Or are these limitations are fair or improvements need to be done to address these limitations? That should be written in conclusion. Right? Or do you want to give any extra rights, additional rights to the Attorney General? That should be written in conclusion. Right? So your conclusion will be prescriptive one, suggestive one. Right? Obviously you will tell the examiner what additional responsibilities you want or what existing responsibility you want to cut off of the Attorney General, or what additional rights you want for the Attorney General, what the existing right you want to cut off, right? Or what the limitations you want to address of Attorney General in conclusion, right? So the conclusion will be kind of in continuum of the body parts, right? So your conclusion will complement the body part, right? That's how you will get highest marks. Clear? Then what the most of the candidates do the mistake, common mistake, is they avoid this statement to get addressed in the answer, right? they straightforwardly start writing responsibility, rights and limitations. But you need to remember that if the UPSC or the examiner has given you a statement, it means it's the part of question. It's the part of question. So that's why you need to address this statement also in your answer. Then the question arises, how will you address this statement? How will you address this statement? Very good. Your introduction in this answer will be a comment on the given statement, right? So your introduction again will complement body part, just like conclusion will complement the body part, right? So here your introduction will be of commenting on the given statement, right? The Attorney General plays a crucial role in guiding the legal framework of union government and ensuring governance through legal counsel. You get the point? So then how you will start your answer? The Attorney General, being the highest law officer of the country, provides legal service to the government by providing its expert legal opinion on the given policy or draft legislative matters, and also defending the government, union government, in Supreme Court or in high courts in the cases against the government. Get the point? So you are addressing legal counsel and also guiding the legal framework of the union government part in your introduction, right? Now coming to the responsibilities part, right? Now coming to the responsibilities part, you know about the Attorney General have primarily two major responsibilities. That's offering legal advice to the government and defending the government in court of law, right? But for addressing this question, you need to add some more points also. So how will you add some more points? Because 2 points are not enough, right? So will you cook new points on your own? No. What you will do smartly is, like, first you will make a subheading, right, as per the given statement itself, like guiding the legal framework of union government, right? Like guiding union government on legal matters, right? So then under this, right, it gives advice on constitutional matters, right? For example, amending the constitution for EWS reservation, right? Then write about that it gives guidance or expert opinion on draft legislative proposals. That's basically draft, or you can say bills. You get the point? Oh, yes, for example, on abrogation of 370, right? Or prevention of money laundering act and so on, right? Or it also gives advice on policy matters, right? Then make a second subheading. Make a second subheading of acting as legal counsel for government, right, as per the given statement. So here you could write defend the government in constitutional cases, right? For example, on EWS case or in Article 370 case and so on. Then you can talk about the defending the government or putting forth the perspective of government on challenge of challenge of laws or acts, the policy, scheme, or any regulation or ordinance, right? For example, Tribal Reforms Act were defended by Attorney General, Aadhaar Act has been defended by Attorney General, and so on, right? Then you can make point of putting forth the perspective of government on the cases of being heard by Supreme Court under its advisory jurisdiction. You get the point? For example, recent hearing of case of this governor's power. Right? Supreme Court has given verdict that governor should assent to the bill within prescribed time limit. And such has been referred by the president for Supreme Court advice. And such case is being heard. And the government perspective, government stand is being put forth by Attorney General before the Supreme Court. You get the point? So points were 2, but smartly you have stretch it to 10 points. You get the point? That too in brief manner, right? That too under the subheadings as suggested by the given statement of the question itself. So you have addressed this statement in first in introduction, then second in body part. You get the point? So basically you have written your answer in the context of this statement. By taking this statement as reference, you have addressed the subparts of the question. You get the point? If you write this in this, if you write your answer in this manner, you will get highest marks. Clear? Because you have addressed the subpart, you have addressed the statement, right? And you have made these 2 subheadings, right? That guiding union government on legal matters or acting as its legal counsel. So basically you have sub-categorized your points, right? That's also a way of presenting your ideas. One way is writing these 10 points, right, in your answer. Second way is make 2 categories, right? 4 or 5 points in under one category and 4 and 5 points under second category. So tell me, which one is a better presentable format? Writing all points in haphazard manner, in jumble up manner, or categorizing these points under 2 subheadings? Is categorization right? So your presentation also get better. It reflects that how clear you are in your expression, how precise you are in your expression, right? Examiner will get extremely happy by your answer and will give you highest marks. Even one of my friend was there, he got 80 rank. I asked him after his selection, and how got you such rank, right? Because he has just 10 or 20 marks extra than me in GS, right? I asked him that how you get these 20 marks extra than me, right? He told me that he has categorized the points in his answer. You get the point? These smaller things will create impact. How? See, there are 20 questions in one GS paper. By this subcategorization, right, I have written such points in haphazard or in jumble up manner, right? So I may got suppose 3 marks out of 10, but he have written the answer by categorizing the points. So he will get 3.5 marks out of 10, right? 0.5 marks extra than me, done for 20 questions. How much extra marks he got than me? 10 marks, right? There are 4 GS paper, 40 marks extra. He was in the list, but I was not. You get the point? So these things may look smaller, but they are impactful. You get the point? Clear? So these points are written in haphazard manner, jumble up manner, but you will write in categorized manner, and categories you will take as indicated by statement of the question. Clear? Then you will write rights like it can participate in parliamentary debates, speak, but no voting right. It has access to government files and documents for offering legal advice. Third, he can sit in any court of India. He can appear for government of India in any court. Right? You get the point? Then limitations, advisory opinion only. It's up to the government to accept its advice or not. Then it acts on the aid and advice of the Union government. It means it will defend those cases only which are referred by government. Right? That too by Ministry of Law and Justice, which create procedural complexity. Unless and until the case is referred by Ministry of Law and Justice, Attorney General will not take up that case. Right? Then it cannot practice privately against the Union. cannot take up the case of criminal nature without government approval, cannot become director of any company without government approval, right? Term is not specified by the constitution, depends on president pleasure, right? And sometimes attorney general, despite being a constitutional office, defend not the government but the political party or leader in power. For example, during UPA rule, attorney general defended the corruption of the government in the court of law, right? In 2G scam, you get the point. So sometimes attorney general serve political interest, not the constitutional interest. Clear? Yes, because attorney general sometimes forget that he or she is a constitutional office. He start thinking that he is being appointed by person holding prime minister office. So he is accountable to the person, but he should be accountable to the constitution, right? To the prime minister, not the prime minister office, or you can say prime minister position, not the person holding that office or occupying the chair. You get the point? So that also you could write. You get the point? And in conclusion, I have told you here some suggestive conclusion you can write. Right? Now coming to the next PYQ. Let's basically compare and contrast the president pardon power in India and in USA. And are there any limits to it in both the countries? And what are preemptive pardon? Again a lengthy question in 10 marks. Again you have to write in concise manner. Right? So here first part is you have to compare and contrast president power. For that you can draw a table. Right? Again limits has been asked. So such table could be extended to write limits also. Right? Then in the last you will write about preemptive part. That's the body part. So now how will you ensure logical flow in introduction and in conclusion? In introduction you can simply talk about what power is being in question here? Pardoning power. So you can talk about pardoning or mercy power of the president. Right? So you can talk about why such mercy power has been given to president. Right? To rectify judicial errors or for national interest, for national security, etc. Right? Or you can talk about that Article 72 of the Constitution provides pardoning power in Indian president. Obviously, you do not know about which article provides to US president, right? But at least you know about Indian president. Yeah, right? You get the point? That's how you can start your answer. Now, in this question, many aspirants may get feared that they do not know about presidential pardoning power of USA. Right? Then how then they will write the answer? So first, you need to get relaxed in the examination. Do not get panic, right? And just think for a while, and you will get certain points to write in your answer. Right? For addressing this question, you do not need to read US Constitution. Right? You just need to have basic idea about US president's presidential power. Right? US president's pardoning power. Clear? So the point is, do not try to read US or UK's or Japanese constitution, etc. Right? And why this question was asked? Because it was in news. Because Donald Trump, after coming into power, has pardoned the protesters who have vandalized or done violence in White House when he lost power in his first term in 2020, right? So that's why certain articles were there in Indian Express, etc. That's why this question was asked. Clear? Introduction also, you can talk about the current affair event that recently US President has pardoned the Reuters of White House of 2020, right? That could also be your introduction, setting the premise for comparing and contrasting the presidential pardoning power of India and USA, right? That will be part of your body part. Yes, yes, good, very good. So I've just told you to relax your muscle, you get the idea, right? So that these are the points you have to write. For example, you know about India's president pardoning power. That's extend to union offenses, right? Same is the case for USA president, right? Just try to think. That will be also the case of USA president, because you know that USA is a federal country. So obviously president can't pardon state offenses, right? It can only pardon federal offenses, union or center's offenses, right? And you just add president has the power to pardon death case in India, just to make it a different point with that of president of USA, right? Then here judicial review can happen, right? We have discussed in Kehar Singh case, Supreme Court held that president pardoning power is subject to judicial review. But in USA, president pardoning power is not subject to any judicial review, right? Then here president acts on this point you have suggested on the advice of Council of Ministers. You know that here president act independently. The secretaries just act as advisors, right? But here president take individual decision. Here, yes, Council of Ministers headed by PM that take collective decision. Clear? So that simple points you can write in your answer. Are they difficult to write? Right? Are they required any specialized study? No. So you have to just connect the dots in different chapters, right? Like of federalism or separation of power or of executive, etc. And you get the points, right? This part content you clearly know, right? Because all these things have been discussed in your static class or are there in your textbooks, right? But this is also there in your class discussion or in your textbooks, but in different chapters. You have to just relate it with the given content of pardoning power of president. You get the point? That's why frequent revisions are necessary for getting command over polity. If you have done suppose 4 revisions, these points will come quickly in your mind, right? But if you have done just 1 revision, right, these points will not come in your mind. And what then you will blame that these things were not covered in your class or was not there in your textbooks. So you need to read extra, right? Or you may need to do attending the classes of some other teacher or some other coaching institute, right? So by doing this, you will be going wrong direction. The right direction is read the class notes or the textbooks multiple times so that you can connect the dots in the examination. Not completely. That's here also only union offenses are pardoned. Here federal offenses, right? Here independent, but here collective. You get the point? Now coming to this second sub part of the question, that what are the limits in both the countries, right? Here you know about limits, that president cannot act as court of appeal to the Supreme Court. You know about that there is limit that president cannot try state offenses, right? Yes, only governor can do so, right? Then president cannot do self-pardon, right? In America, the American president cannot do pardoning of impeachment, his own impeachment, right? Basically self-pardon he can't do, right? So that's the extra point I think you may not be aware of, but that's okay. But at least you know about that, the limits of Indian president. Make it frame like they are limits of both presidents, like both American and US president cannot pardon state offenses, right? Both could not act as court of appeal. Both cannot exercise power mala fidely. You get the point? You will be able to address this part of the question also. Make it similar. Your wording should make it similar. If you do not know the difference, at least, yes, you know about the similarities, and make it so journalistic that it appear that they are true for both. If you go into specifics or technicalities, examiner will catch you that you have written something wrong, or you have written something which you yourself have cooked, right? So examiner will deduct the marks for it. But if you make it journalistic, right, make a generalistic point, general points, right? Both cannot try state offenses, both cannot exercise power mala fidely, right, and so on. Examiner will think that these points are correct, if not false. You get the point? And it will give you marks for it. Then third is, what are preemptive pardons? This word you may not have heard of, right? Even most of the aspirants have not heard this term. 99%, even 99.99% candidates do not know about this term in the examination, right? So the point is, you do not need to get panicked that you have not read preemptive pardon, that's why you can't write this subpart. You have to just relax, right, and try to recall whatever you have understood, whatever you have read in pardoning chapter of your polity, right, and then try to relate it with the given concept being asked in the question, right? So pardon, you know, right? Then coming to this word preemptive. Preemptive means preventive, something done beforehand, right? That meaning you can get in the examination of preemptive. Then relate both. So preemptive pardon could be president pardoning somebody before even get convicted by the court. Be preventive pardon. Just write it. You get the point? So how you are getting the idea of the concept? Just by reading the keywords of the given concept carefully. You get the point? For example, UPSC has this tendency of asking these kind of concepts in the questions. For example, last year they asked, what is demographic winter in GS paper 1? Right? The aspirants may get panicked. This is the new concept UPSC asked, right? But actually that was not a new concept. When any country's population consists of predominantly of youth, then it will be called as demographic dividend, right? You get the point? If country's population is dominated by old people, right, it will be called as demographic disaster or demographic end, right? UPSC used the word demographic winter. Then tell me, you know about demographic dividend? You know about demographic end, right? But UPSC asked you demographic winter, right? Then tell me which demographic winter will be relating to which of these concept, right? That was basically the explanation of demographic winter. You get the point? So do not need to get panic in the examination. Just try to think over what could be preemptive pardon, and you will be able to write it in the examination, right? So in India, can president do preemptive pardon? No, it can do only after the conviction, right? But in USA, president can do preemptive pardon. For example, Donald Trump has preemptively pardoned one of his colleague who was going to be convicted in one of the corruption case in election. You get the point? So that you don't need to write in the examination, right? Just write what is preemptive pardon. Because UPSC has not asked to elaborate the preemptive pardon of US president. It just asks what could be preemptive pardon. You have to just give the definition of it, right? So pardoning the individual before his or her conviction. And just write, in India, Indian president does not have such power. Just, you get the point? Now coming to the conclusion, what would be the conclusion? Summarizing conclusion you can take, or a balanced conclusion also you can take. For example, you can talk about this pardoning power helps the executive to correct the errors of judiciary, right? Or such pardoning power should be exercised in extreme case, extraordinary case, not in regular affairs, right? Should be exercised bona fidely. You get the point? A balanced, a recommendatory, a summarizing conclusion you are taking for this answer. Clear? And that should be in one line only, because here no limitations or challenges or criticism is being asked, right? You have been just asked comparison and definition of preemptive pardon. You get the point? So that's why conclusion will be of one line, balancing or recommendatory or summarizing. Clear? You get the point? Yes, online students, please confirm. Whatever we have discussed so far is clear to all of you? Are you getting the idea how to write good answers of polity? So YouTube has this delay of 30 seconds to 1 minute of streaming of the class. So yes, online students, please write in your comment box. I will see later, right? So now continue to the next question. That's question number 5. Yes? They sometimes refresh the page, right? Now coming to the 5th question, that Indian Constitution is conferring the amending power on the ordinary legislative institution with a few procedural hurdles. In view of this statement, examine the procedural and substantive limitations on the amending power of the Parliament to change the Constitution. So it was there in 15 marks question, 250 words, right? So you will be given 3 pages for it, right? So here you have been directly asked procedural and substantive limitations, right? And the tail word is examine, right? So then you need to write the criticism or significance of such limitations on the amending power of Parliament. You get the point? Obviously your body part will consist a subheading of procedural limitation, then second subheading of substantive limitation, third very brief, the significance and criticism of such limitations, right? And we have just discussed that the statement, the given statement is also part of the question. The Indian Constitution has conferred amending power on ordinary legislative institution with few procedural hurdles, right? So that also you need to address. How you will address? By making a comment in the introduction. that Indian Constitution conferred the amending power on the ordinary legislative institution. For that you will write that Parliament has been given the power by the Constitution to amend the Constitution, right? And Constitution has not provided for creation of separate constituent assembly for amending the Constitution. And Parliament follows, by and large, similar procedure of ordinary bills of first reading, second reading, third reading for passing the constitutional amendment bill, right? So this will address ordinary legislative institution aspect of the statement. You get the point? These procedural hurdles will get addressed in procedural and substantive limitation section, right? So introduction is clear. So now coming to the procedural limitations. What were those? Like 2/3 majority, half of the state ratification, presidential assent, right? And such constitutional amendment should be passed separately. That's why no joint sitting could happen, right? You get the point? So now coming to the substantive limitations. What is that? Basic structure doctrine, right? Constitutional amendment cannot violate basic structure doctrine, and you need to mention Keshwanand Bharti case also, and you need to mention what are certain basic structures, for example, secularism, democracy, rule of law, right, and so on. Then in this substantive limitation there is only one point, but one point is not enough, so that's why you can cook smartly 2 more points. For example, judicial review can happen on constitutional amendments if they violate basic structure. That also comes under substantive limitation. Third is it could not violate fundamental rights, right? Fourth, you can add a point that this constitutional amendment acts should be fair, just, right? So it should follow due process of law also, that this constitutional amendment act should be fair, just. You get the point? So that's how you will add points in the under this subheading. Clear? Because under this subheading, actually there is only one point of basic structure, right? But you need to add 3 more points also to justify the creation of separate heading in your answer. That you need to do smartly. How smartly? It should not appear as repetitive of first point, right? It should not appear as repetitive of the first point. Second, it should appear as valid and distinct, right? It should appear as valid and distinct. Clear? Like judicial review or non-violation of fundamental rights or such amendment act should be fair and just, right? Obviously you need to complement your answer with examples. For example, ratification of state you can give of GST, special majority you could give of EWS reservation, right? Or presidential assent you can give of recent empowering of states for creating their own OBC lists, right, and so on. And also in substantive limitation you can talk about the struck down of National Judicial Appointment Commission for violating basic structure of judicial independence. You get the point? Examples should be there. So how will you conclude? See, the tail word was examine. So you can add criticism also of procedural and substantive limitations. Not suggestions, first importance, right? Then criticism, then in conclusion you can add suggestions. So importance and criticism is part of your body. Suggestion is part of your conclusion, right? Importance, you can say that it has prevent radical changes in the constitution, right? And it is different from ordinary legislative procedure as 2/3 majority is required. That's why it's not easy to change, right? And constitution is able to be organic, to change itself as per changing needs of the society and so on. The criticism, in brief, you need to write that Unlike USA, state has no role, right? Second, majority of the part of the constitution could be amended either by law of the parliament, for example in article 4, creation of states, or by simply constitutional amendment bill without requirement of any state's ratification. You get the point? And still these procedural or substantive limitations are not enough for ruling party to change the constitution radically. For example, Indira Gandhi did by 42 Constitutional Amendment Act. You get the point? So these things you need to write in criticism. In conclusion, you can add certain suggestions for improving these procedural and substantive limitations. For example, again in conclusion you will make two headings: suggestion for procedural limitation strengthening and suggestions for strengthening substantive limitations. For procedural, you can talk about that state ratification should be made mandatory, right? You can talk about state should ratify it by passing the resolution by 2/3 majority. You get the point? Or in procedural, you can talk about the states should be given power to initiate constitutional amendment constitutional amendment procedure, just like in USA. You get the point? In substantive, you can talk about that there should be constitutional amendment for writing down the basic structure of the constitution, right? That you can add in substantive one. Or there could be provision of constitutional convention or the constituent assembly for making bigger or major changes in the constitution. The people of India will elect the constituent assembly members. You can add these kind of suggestions. You get the point? That's how you will address this question, right? Or there should be periodic setup of National Commission for Review of Constitution, which will give the recommendations for amending various provisions of Constitution. That also you can add, right? So how you will score maximum in this question? Addressal of the statement, then procedural substantive, complemented by examples. They should be complemented by examples, right? Then writing importance limitation, that too in single line only, right? Then writing the conclusion by writing the suggestions for both procedural and substantive limitations, right? For this thing to work, you need to be quite quick in recalling all the points. Get the point? The more you quicker you are in recalling the points, better, and within the time limit, you will be able to write the answer. If you are taking time to recall the points, right? You are taking, this is 15 marks question. You should write this answer in 10 to 12 minutes. But you are taking 20 minutes to write the answer because you are recalling the points, right? Then you will miss out many questions in your paper to be answered. You get the point? So that's why again revisions are important. Clear? Do you think any question so far go beyond the scope of class discussions or your textbooks? Do you require to read bulky Sarkari Punchi Commission reports or the bulky textbooks of Supreme Court lawyers and so on, or any the summaries or the key points being written in textbooks of different authors or mind maps books of polity of different authors, right? You just simply need to restrict yourself, limit yourself to the class notes, or you can say the standard text. What is that standard text? Lakshmikant, along with current affairs, right? That's more than enough for writing the best answers of polity. You get the point? You need to excel in covering class notes, or you can say Lakshmikant, and the current affairs. More you are better in this, higher will be your marks. The only difference between the topper, and the non-selected candidate will be the coverage of the standard text, or you can say class notes, and the current affairs. You get the point? Better you do it, greater will be your marks and greater the chances of clearing this examination. Clear? Now coming to the next question. The second last. No. Fourth last actually. There are 9 questions for 2025. Right? Here you have been asked, discuss the evolution of collegium system in India. Detail examine the advantages and disadvantages of the system of appointment of the judges of the Supreme Court and that of USA. Right? And that of USA. So again, why USA has been asked? Because it was in news. That Trump has appointed a judge in Supreme Court of USA who has sexual allegation against him. Right? That's why there were articles in Hindu and Indian Express. Clear? So here it is being directly asked the evolution of collegium system in India. We will obviously talk about Article 124. You can talk about in introduction. That will set premise for appointment of judges through collegium, which says Article 124 says President shall appoint Supreme Court judges in consultation with CGI and as many as other judges as he may deem necessary. You get the point? So in introduction you are telling what is the constitutional method of appointment of judges. Then you will come to evolution of collegium. You need to talk about first judge case, second judge case, third judge case, then 2004, 14, 99th Constitutional Amendment Act, NGC Act, then 2015, fourth judge case, and the present memorandum of procedure. Right? That's basically the evolution of collegium system. But the tail word is discuss. That's why you will make a comment on this, that this system ensure judges are appointing fellow judges, and more or less in memorandum of procedure, that's the current process of appointment of judges, is following the old collegium system, right? Certain reforms only, right? So that will address this discuss part. Get the point? Then in the next part, you have been directly asked advantages and disadvantages of appointment system of judges of Supreme Court of India and USA. For that, you can make table, right? So here you write Indian judge appointment, Supreme Court judge, USA judge appointment. So in the first, describe how they are appointed. Here you have been asked advantage, disadvantage, but give a brief about how they are appointed. So in India, you know about appointed by President on the basis of recommendation of collegium system, right? CGI and 4 other judges. And in USA, President appoint on his or her own, but they should be approved by Senate. That's their Rajya Sabha, right? You get the point? And you know that Senate functioning is open to public, right? How they are, on what grounds they are approving the judge's appointment, on what grounds they are rejecting judge's appointment is open to public. It's streamed live before the public. You get the point? So if you just know this much information, you will be able to write advantages and disadvantages. And how will you know about how Supreme Court judges in USA are appointed? See, first by current affairs, right? Because this was in news in the last year, right? Second, if you have not read the current affairs, then how will you answer this question? Just assume that judges of Supreme Court are appointed by President of USA. Then do the advantages and disadvantages. You get the point? This much actually you know, right? And that part you can discuss in advantages and disadvantages. Obviously you will not get the full marks, but surely you will not get the low marks. You will get above average marks. You get the point? So then you will make advantages in one of the row section, write the advantages in bullet format, then disadvantages, bullet format, right? In conclusion, what you will write? Suggestions for Indian appointment of judges. We can follow USA model of approving appointment of judges by parliament, right? Then, but do not directly refer that such system should be followed. You should complement it with other appointment procedure being followed in the world. For example, I've told you NJC system is being followed in UK, where civil society members are also part of National Judicial Appointment Commission, right? So you can talk in conclusion that the mix of US model, UK model, etc. we can also follow for Indian judges appointment, like approval by parliament and NJC creation, which have members from civil society, academicians, etc. also. In conclusion, not only about USA, right? We are talking about mix of both USA and UK, because we can't say that USA system is best, our is completely worst, right? Our system, USA system, UK system, all should be combined to form a unique system, right? Because each system has its own advantage and disadvantage. We have to take advantages of all and try to address disadvantage of all. You get the point? So that should be reflective in your conclusion, because our constitution is made on this model by combining the best of presidential system and parliamentary system, by combining the best of unitary system and federal system, by combining the best of liberalism and conservatism, by best of capitalism and socialism, and so on. And that should reflect in your conclusion. Clear? You get the point how you will structure your answer, how will you maintain logical flow, right? So here the evolution part is quite important, right? And in advantages and disadvantages part, you can't write examples. So that should be written in bullet format, in tabular format, right? So here judicial independence is ensured, executive interference is reduced, but here legislative and executive both have oversight over appointment process. It is publicized process because general public also get to know on what grounds are judges being appointed, right? So here transparency is not there, here accountability and transparency is there. You get the point? Here nepotism could be there, here no such nepotism. Clear? Or if you want to add example, you can talk about in USA political appointments are being made in Supreme Court, right? For example, I've given you of recent one, right? Or in India, nepotism is followed. Like you can give example of recent acquisition of appointment of judge in Bombay High Court, who is distant relative of current CGI. You get the point? So that you can mention, but do not name the CGI. You can just mention that appointment of judge in Bombay High Court, who is distant relative of CGI, right? So then this example also you can add in table itself, like here make a row subheading example and write the example. You get the point? The conclusion already we have discussed, right? You get the point? So conclusion will be a balanced one with a tone of, with an element of suggestions, right? Because no system is perfect. We need to blend the both, so to enjoy advantages of both. Clear? You get the point? So far so clear? Now coming to the next question. Examining the evolving pattern of center-state financial relation in context of planned development in India, and how far has the recent reform impacted the fiscal federalism? That's basically center-state relation. It was asked in 15 marks, right? 250 words you need to write. So it's little tricky question because the first part of the question asks you to confine yourself within center-state relation. You need to confine center-state financial relation within planned development in India, right? And how the planned development get influenced by evolving pattern of center-state financial relation is basically asked by examiner in first part of the question, right? So this much has not center-state financial relation we have discussed in the class. So how the planned development involved in India is basically discussed in economy, right? But you need to interlink economy and polity here, right? So here interlinking of subjects is required to answer the question thoroughly, right? And recent reforms has been asked. That's basically recent means by Modi government, not in last year, but in last 10 years, right? Impacted the fiscal federalism in center-state financial relations. So how will you start? How? You can talk about constitutional basis, part 12, article 265 to 293 deals with center-state financial relations, right? That you can write in introduction. And if you do not remember the part or articles, then what you can write, that constitution divides the financial power between center and state, including taxation, grants, borrowing, etc. Right? So basically you are giving a brief about what is the existing financial relation between center and state, right? Start from 265, 266 and 267 does not have substantial provisions. So substantial provisions start from 68. You can write 68 also, right? Clear? So you start with constitutional basis. So constitutional articles get mentioned in your answer, right? Then you will talk about how the center-state relation has been evolved, right? For that you do know about that earlier discretionary grants were given by on the recommendation of Planning Commission under Article 282. Now by respective ministries, right? Earlier I told you that Finance Commission used to give share to states in the central pool of taxes like income tax, corporate tax, etc. to the extent of 29% or 26%, 32%. It means there was increment of 3% by successive financial commissions. But 14th Finance Commission and also continued by 15th Finance Commission gives a big jump to such devolution to 42 and 41% respectively. You get the point? Earlier, states were freed to impose their own taxes. We have discussed, like entertainment tax, luxury tax, gambling tax, octroi, etc. But now they have been all merged in GST. So GST is imposed on the recommendation of GST Council, which have members from both center and states. The finance minister of both center and state are member of GST Council, right? That also we have discussed, right? So this only you have to write in evolving pattern of financial relation. In early planning era, Planning Commission gives the recommendation for grants and loans. Now, respective ministries. Earlier, state share in tax devolution was lower, but now greater. Right? Still, centrally sponsored schemes dominate. Right? And recent reforms, Finance Commission giving big jump. Then GST Council, Niti Aayog replacing Planning Commission, but with no fund allocation power. You get the point? And 15th Finance Commission also recommended performance-based distribution of grants, but it has not been accepted so far by the government. Right? That also you can write here. No, that discussion should not go. The question is evolution of center-state relation, not the center-state financial relation. It is not asking you the details or specifics of center-state financial relation. It is asking you evolution. Yes. Since independence, how is evolving? You get the point? How is changing? That changes you need to mention. Then the recent reforms you have listed out. Right? That's the second subpart of your answer. Third will be positive and negative impact. Positive will be center and state are cooperating in GST Council. States are getting greater funds because 42% tax devolution is there. Right? Then central government has also reduced number of centrally sponsored schemes. So states getting greater autonomy to frame their own schemes. Right? But challenges, states still getting lower share or lower tax amounts in GST collections, right? Or state lose their autonomy by submerging their taxes into GST. You get the point? So these kind of points you will write in criticism. That will come under how far have they impacted? How far? It means pros and cons. Right? In conclusion, you will give a suggestions. Get the point? So central government should compensate states for loss in GST, right? And so on. So basically here, I'm not getting into much details because economy has to link it with polity here. So GST, plan development, right? Planning Commission, all these things you read in economy. But still we have sufficient content from polity to address this answer. Yeah. Yes, but Nitya, you also discuss in detail in economy. No, you just need to mention that Niti Aayog has not been given any financial power, unlike Planning Commission. Right? You get the point? Now coming to the next question of constitutional morality. This constitutional morality topic is also getting important because another year UPSC is asking question on constitutional morality. So here first the statement is being given, constitutional morality is the fulcrum which act as an essential check upon the high functionaries and citizens alike. Right? Then in view of the above observation of the Supreme Court, explain the concept of constitutional morality and its application to ensure balance between judicial independence and judicial accountability. So here you have been directly asked explanation of constitutional morality. It means definition you need to write, little bit more elaboration of its features, right? Then its application to ensure balance between judicial independence and judicial accountability. It means how it is applied for judicial independence, how it is applied for judicial accountability, and how the balance between the two is maintained through constitutional morality. Right? But again, one more thing is there. In view of the given statement, it means the statement is setting the limits to the answer in subsequent subparts of the question. Right? So you need to specify its application, or you need to specify the concept of constitutional morality, then its application by referring the given statement. And what the given statement is saying, that is the fulcrum which acts an essential check means limitation or restriction Upon the high functionaries, that's basically president, PM, speaker, deputy speaker, vice chairman, deputy chairman, chairman, right, and Supreme Court judges, and so on. All the offices created by Constitution, and also on citizens. You get the point? So you need to, while explaining constitutional morality, you need to specify how it put checks on high functionaries and how it puts checks on citizens. Your introduction will start with constitutional morality definition, and it will continue with its constitutional morality checking both high functionaries and also citizens. You get the point? Then you need to tell that how it is being applied in judicial independence and judicial accountability. How you will relate with the given statement, that how it puts checks on executive for not encroaching upon judicial independence, and how it also puts checks on judiciary to remain accountable. You get the point? So introduction, definition, constitutional morality, continue with its application of checks on functionaries and citizens. So functionaries, you know about that. PM is PM enjoying pleasure office till the pleasure of president, subject to majority in Lok Sabha. Council of Ministers collectively responsible, right? Judges can be removed, president can be impeached, and so on. So that you will give in brief. For example, how it put checks on higher functionaries, write about removal of president, judges, or chief election commissioner, CAG, etc. Then talk about PM enjoying the office till majority in Lok Sabha, right? And the pleasure of president, or the question or adjournment motions, or no confidence motion, and so on. Right? Do not explain this, just write it. Just make a mention of it. And how it put a checks on citizens, and that you will get to learn in fundamental rights. That's basically citizens cannot practice inequalities. They should not discriminate others, right? They should have fair conduct with others. They should promote fraternity. They should not engage in communal riots, right? They should promote national integration, unity and integrity of the country, should not be engaged in language wars, right? Or regional wars, whether Maharashtra or Karnataka, which one is better, and so on, right? And so on. So citizens also have certain responsibilities by constitutional morality. Constitutional morality is the values or principles of the Constitution, or spirit of the Constitution, which everybody has to imbibe, whether the office is created by Constitution, institutions created by Constitution, or by the citizens. That one you can write, right? We should be tolerant toward other religions, right? Or the keywords written in preamble, like fraternity, justice, that also you can mention. Then citizens also have the responsibility to ensure democracy, a sound democratic functioning in the society, in the country. Like if the Prime Minister or CM is acting authoritatively, then citizens should raise their voice. Right? If they are misusing the power, then citizens should raise their voice. They have the responsibility to ensure all the institutions remain in check. Right? So for smooth functioning of limited government, for smooth functioning of democracy, right? For the smooth application or implementation of Constitution, whatever is required, it will be part of constitutional morality, and such following of constitutional morality is responsibility of all the constitutional offices, occupants, and citizens. Right? And you can also mention that here in the statement, that in the light of above observation of Supreme Court, right, you can give a reference of Supreme Court also in your introduction, because Supreme Court has observed the following of constitutional morality. Do remember, we have covered it in class, that in UT case, that while giving judgment on UT of Delhi in 2018, Supreme Court advocate following of constitutional morality by both central and state government. Then in Mela case also, Supreme Court emphasized following of constitutional morality for granting access to menstruating women to Mela temple. So you need to write just in, you can write in this manner, that in Mela case and in UT of Delhi case 2018, Supreme Court has observed the following of constitutional morality by both high functionaries and citizens alike. Right? So this part will get addressed by this line. Get the point? So then you need to write about constitutional morality. Right? And then how it will be applied in judicial independence. Executive should not try to control judiciary by appointing its favorites into judiciary. So that will be upholding of constitutional spirit, constitutional principles, constitutional value of ensuring judicial independence. Right? And what is judicial accountability? Judges should not act as godfather of this country. They should not try to encroach upon the legislative and executive powers. They should not try to do judicial overreach. They should not do corruption. They should disclose their assets publicly. They should not appoint their favorites or their relatives as judges by misusing the collegium powers. Leaders show, yes, because that will be upholding of constitutional morality. Right? You get the point? How balance could be made between two? Like independence without accountability risk judicial overreach, but accountability without independence risk executive dominance. Right? Then conclusion will be like independence need to balance with accountability, and you can write even value-based quote, value-based conclusion. For example, you can end your answer with a quote that powers, the great powers, with great powers comes with responsibilities. Right? You get the point? So that's how you can end this answer. Clear? So now that's the last question. Election topic has not been covered in the class, right? But I will try to give a brief about. Question says, discuss the corrupt practices for the purpose of Representation of People Act 1951. Right? So here you have been specifically asked what are the corrupt practices for Representation of People Act. Right? The Representation of People Act, basically Representation of People Act is enacted to ensure free and fair election in the country. Right? So that will be your introduction. Representation of People Act 1951 enacted for ensuring free and fair election in the country. Right? In this act, corrupt practices are mentioned. If any candidate or the elected MP or MLA do such corrupt practices, they will be disqualified from the office. Yes, overspending, like, or bribing the voters, right? Or instigating the people for riots to win the election, or spreading hatred amongst different communities, right? All they are part of corrupt practices. For that, they could be disqualified. And how they will be disqualified? By High Court. Right? Such disputes of corrupt practices shall be settled by High Court. Right? If High Court basically hold them guilty of corrupt practices, then Election Commission will recommend President to disqualify them. Yes? And they will get disqualified from the office. I think this much I've discussed a little bit in Parliament chapter, right? Details we will discuss in election chapter. Clear? So that's basically corrupt practices. Second is analyze whether the increase in the assets of legislators or their associates, it means relatives, friends, etc., disproportionate their non-sources of income would constitute undue influence and consequently a corrupt practice. So the question is itself giving you clue that undue influence is a corrupt practice, right? And undue influence is like intimidating voters by death threats, right? Or bribing the voters and so on. That will come under undue influence. And the question is asking that if they have disproportionate assets, it means if they have done corruption while being in office, right? Then that corruption will come under undue influence definition or scope or not. And if it comes under undue influence, then they will get disqualified for doing corruption in the office, right? So here the question is asking that whether the increase in assets disproportionate to their known source of income would constitute undue influence or not, right? So it means the question is indicating to you that directly increase in assets is not undue influence. It will be indirectly linked to undue influence, right? So basically you need to specify how it will be indirectly linked. You get the point? So to address this part of question, first you will address increase in the assets of legislator. You will write that MPs and MLAs quite often have disproportionate assets and they have the acquisition of corruption being done while being in office, right? Taking bribes for tenders and so on. Then you will write, you will specify undue influence, right? Undue influence is bribing the voters or intimidating the voters or cheating the voters or defrauding the voters and so on, right? To win the elections. And how they can be linked. That will be your third subpart, right? How it could constitute as undue influence. Then you will write that it would be undue influence by way of cheat because the MPs or MLAs candidates have not disclosed their true assets. The voters are thinking that they are from average family, but they actually from rich family, rich financial status. You get the point? They show themselves as from humble background, but they actually from privileged background. Then second, it will be a cheat because they may have earned such income from illegal sources, maybe from drug trafficking or illegal sale of liquor and so on. Third, they have not disclosed their corrupt practice while being in office of getting government tenders to their relatives and so on. Again, they are violating or they are cheating the voters by hiding the truth. My wife, children, right? So that's how you will relate it with undue influence. Then in conclusion, you will write that such will not come directly under the scope of undue influence, but it would come under scope of undue influence indirectly, but we should make it explicit or direct or specific or clear by amending the Representation of People Act. That if any MP MLA got disproportionate increase in income, right, then he or she should surely be disqualified to curb corruption, right, in the functioning of legislators, and such has been observed or recommended by Supreme Court also. Yeah, they have to give the known source of income. If they have income greater than the known source of income, then they should be surely disqualified by assuming that they must have done either from corruption or from illegal sources, like illegal mining, illegal sale of liquor and so on. You get the point? So that basically you need to write in this answer. Right? This also, if you have not read in detail, by just thinking or pondering over the statement, you will be able to write it. Right? You get the point? You have to just think it, even if you have not read the act in detail. Right? So that's why, how will you prepare polity now? Revise your class notes or the Lakshmikant multiple times. Class notes for the class students and Lakshmikant for non-class students, right? Read current affairs regularly. Just one newspaper is enough. And if you are a class student, then classes are enough, right? Everything of polity will be, which was in news, will be covered in the class, right? And revise it multiple times. Practice the prelims questions of it, practice the mains questions of it. That's it. Get the point? But do not do anything extra, because UPSC is not asking anything extra. If they start asking, suppose from reports of Sarkaria Commission or Punchi Commission, right? The bulky reports of Dinesh Goswami Committee, in the Indrajit Verma Committee and so on, right? And if it start asking from detailed Supreme Court verdicts of 1000 pages, or start asking questions from the books written by constitutional experts or luminaries or the former Supreme Court judges or from Supreme Court lawyers and so on, then we will read it. You get the point? But if UPSC is confining itself with the prescribed within prescribed syllabus, then we should stick to the syllabus only. You get the point? So topper will be that candidate who excel in the given limited source. That's basically class notes for you, Lakshmikant for other students, and the current affairs, right? And how well you present or express the given information will decide your selection. Get the point? So that's all for today, right? And I hope you get to learn something from this session, right? So to online students also, I wish a very happy learning. Thank you very much to all of you.